Hi, I'm Magdalena Rico Palau. I am a lawyer specialized in banking claims. These lands that surround me were part of a large urban project called Golden Sun and Beach Resort, a big project with more than 3,000 homes and even a large golf course. As you can see, the project was just executed, and only about 30 homes were delivered within the term. The rest of the buyers of off-plan houses never recovered their money. The residential promoter Aguas Nuevas had general guarantees from Bankia but never granted individual guarantees to the buyers. They are the guarantees that guarantee the return of the amounts delivered to account. In this case, despite lacking individual endorsements, the Supreme Court of Spain confirms that buyers of off-plan houses can claim their deliveries to Bankia because the general guarantees are sufficient guarantee. How? We are going to explain it to you next. Bankia has been condemned to return to several buyers of Bahía de Pulpí, Golden Sun and Beach Resort the amount of €500,000, plus interest and costs, even though they did not appear as beneficiaries of individual guarantees. It is a judgment issued by the Court of First Instance No. 3 of Torrevieja, in which an extensive analysis of Law 5768, and of the Supreme Court's jurisprudence is made, in relation to the non-delivery of the individual guarantee to the buyers and the lack of income of the amounts in the special account. There is no doubt that this sentence is a great boost for many buyers who thought they had lost all hope of recovering their savings. The judgment of the Supreme Court 739/2016 of December 21 indicates that it is not necessary to have individual guarantees of the amounts delivered by the injured parties, being sufficient that there is a line of guarantees, even if this is later than the moment of the sale. In effect, this judgment says that the plaintiffs did not receive an individual guarantee. But this is irrelevant to enjoy the guarantee assumed by the entity. Sentence 322/2015, of September 23, states that the buyer who has paid amounts on account must not weigh the severely negligent or willful misconduct of the promoter who no longer acquires certificates or individual guarantees. The absence of the corresponding individual guarantees does not prevent the obligation to return the amounts delivered, with their interests, to be covered in favor of the buyers who have entered into a purchase agreement and delivered those amounts on account, under the protection of the existence of a collective policy. Courts admit that those affected by this kind of promotions are. Do not hesitate, it's time to act. Do not give up your savings. Act.